The myth that we are busting today is that if you change something by 10%, then you're not infringing. I'm talking about a copyright work or something that might be under patent or protected by a registered design. I've heard this repeated so many times. A client will say to me, well, I took that blog post and I changed it by more than 10%, so I'm not infringing copyright. Or they look at a registered design and they say, well, I changed it by 20%, so I'm not infringing design protection. The 10% rule is an absolute total myth. With copyright, there's three things that you're not allowed to do. So somebody owns copyright in, I don't know, a photograph, a blog post, training material, and you are not allowed to use it without the owner's consent. So you're not allowed to copy it and use it without their consent. You are not allowed to modify it without their consent, and you're not allowed to broadcast it without their consent. So copying is pretty straightforward. If you copy the whole thing, obviously you're in trouble if you don't have their consent. What about modifying? You're not allowed to modify it, and the law doesn't say you're not allowed to modify it unless you make it 10% different. The law just says you're not allowed to modify it. And so this idea that it has to be more than 10% different is just simply wrong. The courts don't actually look at it like that. What the courts say is, did this thing, this new training material that you've created, originate from the old training material? And if they can see you've taken the old one and either copied it directly or copied it and modified it, you are going to be in trouble. The courts have also said, how do you know if something's a copy? Because you might have modified it. So obviously, if you've modified it and you don't want to get in trouble, you're going to say, no, I created it all on my own. I didn't refer to the other article or the other training material. And the courts are actually quite savvy. They can see if you've made changes. They can see if you've developed it yourself. They can see if you've come up with something on your own. So there was a case in England where somebody had created a telephone directory back in the days when we had books for telephone directories. And they were worried that somebody was going to copy their stuff. So they put 3 false entries in their telephone directory. And when the new person created a telephone directory, they said, we didn't copy. No, Your Honor, we came up with this ourselves. We did our research and we created this ourselves. The new directory had the same 3 fake entries as the old directory. So that's how the judge knew in that case that there had been copying. But don't do it. Don't copy or modify somebody else's things, whether it's 10% or whatever. If a judge is very savvy, they'll be able to tell if you've taken something that doesn't belong to you and just changed it so that you can get around the copyright laws. There is one slight exception. You can look at something and then be inspired by it and then go away and create something wholly your own. But even then, that is a little bit risky, because what can happen is you can be so inspired by it that you bring more of the original into your work than you anticipated. So 10% rule does not exist. Absolutely create your own things from scratch. This is Catherine Warburton, and I am the Legal Lioness.